Now in session.
Thank you, Mr. Hibner and Mr. Cheadle and Ms. Reed Bracey. We're thankful that you both have agreed to participate in this oral argument live streaming via Zoom and YouTube. We've done many of these and they have gone very, very well, and we expect the same here. Please understand that we will conduct the oral argument today in the same fashion as if all of us were in the courtroom together. Mr. Cheadle will have time to reserve for rebuttal, which I understand you've already indicated. And of course, the appellee will have 15 minutes as well. Unless there are any announcements, we'll ask Mr. Hibner to call the case.
Harpeth Financial Services, LLC versus Jim Clay Pinson, Jr. et al.
All right, thank you, Mr. Hibner, and Mr. Cheadle. As the appellant, you have the floor.
Thank you, Your Honor. Appreciate your agreeing to hear this on Zoom. This is tremendously helpful. I represent the plaintiff, Harpeth Financial, the appellant in this case, who asserts a claim as holder in due course of a $3,000 check that Ms. Flora E. Morris wrote to the co-defendant, Jim Pinson. She spelled it Tinson on the check. The check was written December 12, 2015. The calendar shows that was a Saturday. On the check, she wrote for Elixir 1439 Diving Road. In her letter, Ms. Morris's letter to me, actually a year later, after she received a letter from my office asking that the check be paid, she confirmed that she had written this check to Mr. Pinson, although she wrote it Tinson, and she had asked him to come to her house to perform electrical service on her home at 1439 Dividing Road. And she apparently had, in her letter to me, she had a long list of difficulties she had with her electrical service there at her home and her long history of trying to get some company to remedy that electrical service. Mr. Jimmy Clay Pinson, Jr., co-defendant, came to Ms. Morris's home and mentioned or discussed with Ms. Morris what work was to be done and how it was to be done and how much it was to cost. Ms. Morris hired Mr. Pinson to do the work. Ms. Morris met with this individual, Mr. Pinson. She gave him a $3,000 check to Mr. Pinson, directly hand to him in person. And although she, again, spelled his last name with a T instead of a P, she gave it to the person she intended to hire and intended to pay. Mr. Pinson was also the man Ms. Morris, expected to do the work. Mr. Pinson, this was again on a Saturday, December 12th, comes to my client's facility, one of their stores, to cash the check 4 days later, Wednesday, December 16th, 2015. Mr. Pinson presents his driver's license that was introduced at the trial court, endorsed the check in his name, and received payment of that $3,000 check. Of course, the plaintiff's whole position is at that point, the plaintiff became a holder in due course. they gave value for this instrument to the person who presented the check, endorsed the check, and gave it to him in good faith. The business records confirm that, of the plaintiff anyway, confirmed that Harpeth contacted Ms. Morris and confirmed that the check was from her and was payable to the person standing at their counter. Now, we were given this file for collection a year later, December of 2016, wrote a letter to Ms. Morris, also to Mr. Pinson, really pursuant to the Tennessee Civil Bad Check Law 47-29-101. In response to that letter, our demand letter, Ms. Morris wrote us back letter December 26, 2016, long letter that was introduced as Exhibit 3 at the trial, and confirmed that she had hired Mr. Pinson, anyway, hired the man that she gave the check to, and had intended to make it out to him, and that he was to receive the money, the $3,000. Now, she did say that she didn't have money in the account and was somewhat distressed about that. The business records of the plaintiff show that the check was presented twice to Ms. Morris's bank. It was returned for insufficient funds. And then later in January, it was returned as stopped payment. Ms. Morris testified 4 years after this occurrence that she stopped payment on the Monday, December 14th of 2015, but her letter and the plaintiff's records suggest otherwise. Your Honors, we submit that this is a straightforward, hold in due course case, parameters of which are set out in 47.3.302A and in our briefs. We have received this instrument for value in good faith without notice that the instrument was overdue or had been dishonored. The case cited by the trial court and by the Appellee in her brief, McCann Steel versus Third National Bank, a 1960 Court of Appeals case, was not relevant to this case at all. That's not a hold in due course case. That's a forgery case in which the payees on 32 different checks were forged, were fictitious, were non-existent, and all the endorsements on those 32 checks were forgeries and fictitious. In that case, the court properly ruled that hold in due course, or the bank was liable for paying over these forged endorsements.
Mr. Cheadle, before your initial time is up, I'd like to ask about two facts that appear to be uncommon or unusual. And one is your client did not contact the payor bank, which I believe is a custom of your bank or a practice. And the other is the check was payable to a business entity, but you allowed the individual to cash it and walk out the door with the cash. To what extent are these facts relevant?
Your Honor, I think as to the first, normally this client testified that they would only contact the payor bank if they were unable to contact the maker. In this case, the testimony was my client did contact the maker. She approved the check, and the recipient of the check was standing there at my client's counter. As to the second, the court's probably seen that Ms. Morris is kind of fluid with the way she spells and documents things. In her letter, certainly that was the case, and in the check even more so. It's not truly to a business entity. It's to Jim Pinson, elect sir. there's no corporate name, there's no corporation listed, no INC, LLC, CO. So the person to whom she gave the check, Mr. Pinson, was to do electric service. And our position is that the payee on the check, the recipient of the check, and the recipient of the money were all the same. Electric service could not be not just the corporate name, but also.
Did Mr. Pinson have a banking relationship with your client?
Well, not as a depositor, but he had cashed checks previously over some 2 years previously. So yes, we did have a relationship with him.
But wasn't there a problem with those checks?
There were 2 prior checks that were presented that were insufficient funds, but the testimony is that Mr. Pinson assisted in getting those checks paid.
Okay. All right. Thank you, Mr. Cheadle. We'll hear from you on rebuttal, Ms. Reed Bracey. Be sure to unmute. We can send Judge Bennett over to help you with that.
Finally. It wouldn't recognize my attempt, but I think I have it now. Can everyone hear me?
Yes.
Thank you.
Thank you. Thank you, Your Honors. Kimberly Reed Bracey Johnson here on behalf of Flora Morris to present her side of the arguments before the court. And she appreciates, like me, the opportunity to do so in this day and time by Zoom. Thank you for that. Miss Flora Morris is an 89, now 90-year-old woman who I would dare say has been victimized in this case from not only the perpetrator, which I think everyone agrees was a perpetrator in this cause, the other defendant, Mr. Pinson, who she knew as Mr. Pinson, but she's somewhat been victimized, as quite frankly, we would all submit that the plaintiff was also victimized by Mr. Pinson. Miss Morris did hire someone to work on her home and paid him, sadly, $3,000. He was to show up, as the testimony shows, on a Monday morning. He unfortunately failed to appear. Not as unsavvy as one would think, she notified the bank and stopped payment on that check immediately thereafter. Now, I think that any finding of fact or factual statement that has been or will be argued today that is contrary to the statement of the evidence or the order of the court should not be considered. And so the statement of the evidence and the court so found that she stopped the payment on a Monday. The man who perpetrated the fraud upon my client went to the plaintiff, Harpeth Financial, thereafter, 2 days after, on a Wednesday. What's important about this case is less about the holder in due course, which we believe that the plaintiff is not, but we're not asking you to reinvent the law on holder in due course. I think not only the court's ruling regarding that case, but certainly when we deal with the good faith clause inherent in the UCC, that we can uphold the trial court under the good faith clause without having to create any new holder in due course law. So what facts are those that would create that the plaintiff acted outside the banking industry standard and not in good faith under the UCC? First and foremost, the bank had one person testify. That individual only testified to the record, and neither of the employees who dealt with the defendant appeared and testified. So solely based upon their record, here's what we know. That the gentleman came in with a check. It was not made payable to him. The name did not even match his name that was under their own records. But most importantly, the identification presented by him didn't match either the person the check was made out to, nor did it match the individual who was standing before them. The identification didn't match either one of them. They did ask for a phone number to clarify with someone about the check, and he gave them a phone number. The court found that, and my client so testified, the number given had never been her phone number, and they could not get a hold of her. So he had to leave, and they said, "You've got to come back with another number." That's what's in their own record. What he did do was leave for exactly 7 minutes, came back with the same inaccurate phone number. Then somebody miraculously answered the phone. And here's where it gets extremely interesting, and where I think there's a lot of lack of good faith, maybe not intent, certainly on behalf of the plaintiff. But when they spoke to the person on the phone, they claimed that they compared her date of birth and her social security number. But nowhere in the record do you find my client's date of birth, and nowhere in their record do you find my client's social security number. So someone did answer the phone and allegedly gave them a social security number and a date of birth, but they had to admit on cross-examination, well, we really didn't have a way to know what Miss Morris's social security number or date of birth was to match it to see if it was even the right person.
So,
They just
counsel, it sounds like you're arguing then that this really isn't a forgery case, and it doesn't seem to me to be a forgery case. You're saying more that this was a case where evidence didn't support that the bank here was a holder in due course because of a missing element.
Yes, Your Honor. We submit, and quite frankly, I wish I could have found a Tennessee case really on point. I couldn't, but I found this delightful Florida case that I referred to in my brief that almost has the identical facts, but for when they called the second time, they did get a hold of the gentleman, and the gentleman still was able to defend it against holder in due course. So the facts in this case are more egregious, and those facts that would render the trial court's holding correct, but perhaps for a different reason, include that this man was in their own system multiple times on having dealt with bad checks before, yet they didn't take any steps to call the bank. He wasn't the entity payee. He endorsed the check different than the payee. His identification, which was presented at the counter, was not only different from the payee, but it was different from the endorsement on the check.
But of course, you would agree, as a holder, then he would be able to do that under 3204, because if a holder brings in a negotiable instrument and it's not payable to the holder under 204, the holder can endorse it either in their own name or the name of the payee. So really, that's not too much of a factor here, is it?
Perhaps not. Now, I will say that the pleadings didn't plead any of that. It only pled under the bad check statute 47.
Well, I was going to ask you about that. There's no, in the statement of evidence, the court adopted your statement of evidence, but there was
Correct.
No specific finding about holder in due course. Was that argument addressed at the trial?
Well, the pleadings didn't address it. The only thing alleged in the pleadings that were ever served upon my client was that it was just the bad check statute. But it was never pled in the petition. Was it argued? Yes. I would have to submit that it did. Was argued by Mr. Cheadle, although not, and his associate at the trial level, but not pled. But I would also submit that the bad faith clause under the UCC would deem that all of these factors, when taken as a whole, would keep them outside of holder in due course. So regardless of whether it's under the bad check statute, which was what was pled, and clearly we had the defense of forgery, which no one claims was not appropriate. But clearly, under the holder in due course statute,
Well, I mean, but going back to the forgery there for a second, the gentleman, there's no question the gentleman that was holding the check was Jim Pinson, and he signed his name Jim Pinson, correct? So that's not
I could make an assumption, but since my client was not present at the counter, we and the ID nor the check nor the account match completely. They are similar enough, you might assume that. I don't know that. To be
so did the identification not show the holder then as being Jim Clay Pinson Jr.?
That is correct. What I spelled out in my brief, so we can assume they're close, and I don't have any way to dispute that it was not the same person, but I wasn't there, nor was my client. I hope that answers your question.
It does. Thank you.
Now, the court further said that inherent in the good faith, bad faith provision of UCC standards were that the actions of the plaintiff, this good faith requirement, if we don't uphold what the trial court did, then it's going to make these check cashing outlets an easy refuge and protection for scam artists, which is exactly what happened. My apologies, I had my phone. Not only to my client, but it happened, quite frankly, to the plaintiff. And so the concept of fair dealing includes not permitting the plaintiff to be an easy, safe harbor for the dishonest. My client at no point talked to the plaintiff on that day in question. The court so found it was not her phone number. They already had bad dealings with this gentleman, and they should have been placed on notice by what they'd done with Mr. Pinson, whatever his name was before. They had it sitting in front of them. The trial court also found, and I think it was quite important, is that all of the steps that the plaintiffs say that they took happened in a matter of 4 minutes. And it's just not believable that all of those things could have occurred in a 4-minute time span. My client didn't get the phone call, and the court so found that and even if somebody answered and gave a social security number and date of birth, they had no way to prove it was her, because they admit they didn't have her social security number or date of birth to compare it to. As to the letter, Mr. Cheadle states that was sent about a year later to my client, and then she allegedly wrote him back. The court found my client at 90 years old seemed to be confused on the witness stand. She had to use hearing aids. She had already denounced that letter in the trial court below, and at the next trial level then said she did write it, but quite frankly made some other statements as she left the stand, making the court find that she didn't seem to really understand. But what she did know, she never had that phone number, and that she never spoke to anyone regarding this check, that they didn't call the bank. She did testify on the witness stand, and the court included in the evidence. She questioned, why wouldn't they just call the bank? Because had they called the bank, it had already had a stop payment.
Does the UCC require another bank to call the payor bank?
Your Honor, I'd have to answer that with the unfortunate answer that I do not know. I did not find that was a requirement. However, what we do know is that under banking custom and usage, that when a bank cashes a check, such as that it has a 48-hour hold, if these individuals are going to cash a check against their own banking industry standard, then the risk should be given to, or should be put on the bank that's doing something against an industry standard and that's obviously making a great deal of money off of it. And that's what I was talking about, the bad faith. We're not talking about one instance, but we're talking about 14 factors which this check cashing service totally ignored in order to try to make a buck. And when you do those risks against the standard, I think it goes against bad faith. And that's why I say we don't have to, by upholding the trial court, the Court of Appeals doesn't have to rewrite the UCC or a holder in due course law. All that we have to do, or I would request that you do, is look at the factors and say that in the UCC and the holder in due course statute comes along with it the statute that talks about the totality of the circumstances and acting in good faith. We don't think that the employees at the bank did anything intentional. Quite frankly, they just didn't do that which a normal banking industry in good faith would do under the circumstances. And they sort of induced their own victimization because of it. My client stopped that check 48 hours before he showed up. If we rule against my client, no one can ever stop a check for any reason whatsoever. Nobody's claiming there wasn't forgery. And I would say my client cooperated. The court found she got Mr. Pinson served once I got on the case. They got a judgment and asked to set it aside because they knew they couldn't get the money out of him and went after a 90-year-old woman. Thank you.
All right. Thank you very much, Mr. Cheadle. We'll hear from you on rebuttal. Be sure to unmute. We've learned to encourage that. So
thank you. Well, last first, Judge Rachel Bell did offer to give us a judgment, but the civil warrant was clear that Mr. Pinson had not been served with process. So we did not wish the court to enter a judgment that was clearly void. Of course, this did originate in general sessions, so the pleadings are ora tenens, oral, and when they came up to the circuit court, there's still a general sessions appeal. We did very vigorously argue holder in due course. In addition to which, there was a breach of this civil bad check statute that entitles us to attorney's fees and treble damages and up to $500 and interest. But I am concerned in the statement that the letter that Ms. Morris wrote 1 year after this occurrence, which was 3 years before she actually testified, so it should have been fresher in her mind. She admitted on the witness stand that that was her letter and was her signature and that she wrote it. In that letter, it refutes the claim that she did testify to, that she stopped payment on Monday, 48 hours later. But her letter shows clearly otherwise. She admits she received a call several days later from the loan company, which she spelled L-O-N-E, like other spelling was a bit fluid, and received a call from them. She told in her letter that Mr. Pinson was there with the loan company. She doesn't remember the rest of the conversation. Now, this is confirmed by the plaintiff's records that show when Mr. Pinson was there, and these records are introduced showing his driver's license and actually a photograph of Mr. Pinson at the counter when the check was cashed. He was present when the loan company, the plaintiff, called Ms. Morris to confirm the check. So although she testified to one thing, it's clear from her own earlier letter that that she misremembered or misspoke on the witness stand. So near in time, she did not stop payment according to all the documentation from both plaintiff and defendant at trial until January. And she says in her letter, frankly, that she didn't have the money in the account. She knew she wrote it for $3,000. She was concerned that she didn't have the money in the account, that she was going to need to transfer it later. So the court is exactly right. The commercial code does not require that the paying bank or the recipient bank call the payer bank. And that did not happen in this case because they'd had a conversation with the maker. The Mechanico case we cited, a holder new course is a holder who takes an instrument for value, that's undisputed, in good faith. That is disputed, but the records we would respectfully submit shows that it was in good faith without notice that it was overdue or had been dishonored or any defense or claim to it on the party of any reason. And those defenses, as the court knows, are very limited. It's got to be duress, lack of legal capacity, illegality of the transaction. None of those are claimed or asserted in this case. Your Honor, respectfully, we're entitled to a judgment for the check.
Thank you, Mr. Cheadle and Ms. Reed Bracey, for your arguments. On behalf of Judge Bennett and Judge McBrayer, we want to thank you for participating today, and we'll take this matter under advisement. Mr. Hibner.
This honorable court is now adjourned.
Thank you.